case. This is cause number 14-19966. The state of Texas versus Calvin Gary Walker. Mr. Walker has was placed on probation. That probation was revoked. He has appealed the revocation of that matter, and we are awaiting the disposition from the Court of Appeals on that. Meanwhile, he was granted a bond on the appeal, essentially for the purposes of repaying the restitution that was owed based upon the jury decision and the court's determinations. And what I want to know is where we are on all of that. The last time we had a hearing, we ordered the disposition of properties to be transferred over to the Beaumont Independent School District that the defendant had owned. And I want to know what the status is on that. I haven't heard anything. I haven't heard anything one way or the other. But I want to make sure that all the transition of the properties were going into the Beaumont Independent School District coffers, and for the people, the taxpayers, to be relieved of some of this indebtedness. And also, what is the status of Mr. Walker's payments toward restitution, which was the major reason that the court allowed a bond on his appeal. And where are those? That's what I'm curious. From probation, can you please, Ms. Sonder, give us an update on all of this? I have something dated January 21st.
Yes.
That you've sent. And has the defense gotten a copy of this? No.
No, I'm sorry, Judge. I didn't know if you were asking me.
Yeah.
I've sent I have a budget sheet that Mr. Walker filled out. I don't know if that's what you're referring to.
No, this is what I'm referring to is
No, sir.
notice. Okay, let me make a copy.
Or email it to him.
Okay, we're gonna get this over to you right now. What it shows is, it looks as though restitution, the defendant has paid over $12,000 to the Beaumont Independent School District so far. That is not including the real properties
No, sir, not
that have been ordered transferred, and that's what this part of the report that you're about to get.
Okay.
It shows a financial determination, and I'm just sending you the cover a page. I'll get the other. It looks like 5 supplemental pages, which consist of the defendant's payments that are made to the probation office since his supervision began.
And I had seen that probably not updated for the last 2 months, I'm guessing, Judge, before our last setting.
Yeah, this is dated January 21st, 2 days ago.
Okay.
So, yeah, but
Did you want a status on the appeal while we're waiting for that email, Judge?
I do.
Sure.
Yeah.
I can get you the exact dates if you need, but about 50 days ago, I filed the appellate brief. The state's was due end of December. They did request a 30-day continuance. Their due date should be coming up in the near future. I'm not really positive who's handling the appeal for the state. I'm guessing they're not in there with you, Judge, but their due date should be around February 1st. And then was there, oh, as far as the property, we were also wondering, I think last time we were here, we had a monetary amount we assigned, which was the tax valuations, and we didn't know how that was going to get credited either. So it sounds like you're already looking into that.
So what do we know from the state on that? Anything?
Judge, I apologize.
No, you're Ms. Nealand.
Angela Nealand is handling the appeal. It's actually being finished up today. It should be filed at the beginning of next week for purposes of informing him.
Come on up. So yeah, he can.
Sorry. Again, I apologize.
No, you do us the honor.
Angela Nealand's handling the appeal. That'll be finished today and filed early next week. And obviously it covers a myriad of issues that they've raised, including the property, the original revocation, a bunch of different issues, of course. And all of that is working its way through the system. So obviously we have a concern that we don't want to do anything to disrupt the appeals process. But as far as the property valuation, we haven't really been involved in that because obviously we were opposed from the beginning, but I know he signed over some things. We later discovered after the hearing, there was a quite substantial tax delinquent bill attached to those. But again, we're not involved in that. I don't have any information with regards to that because we haven't looked into it or been part of that.
Thank you. Well, that's going to, I don't know how we're going to resolve it, but it's got to be resolved somehow but the Beaumont Independent School District, their leadership has always stated they want to recover all that they can from Mr. Walker on his obligations that were dealt with in this trial. And so the court is running out of assets of the defendant to turn over. And those two properties, if there are tax consequences, those are going to have to be dealt with, and that's going to have to be resolved to net what is going to be determined that will be transferred over in monetary value to BISD. What's being done about that? I don't think I'm supposed to do it, but what are we supposed to do?
So Judge, from Mr. Walker and my perspective, we signed the quitclaim deeds. I stuck around, made sure they got filed with the proper clerks. And I think you actually helped me out with that. So I can't remember what the issue was, Judge, but we got those filed. I don't think that he owns the properties anymore. And so if anything else is needed to transfer those, let us know. But my understanding is, BISD owns those properties. I think it's 3 properties now. I mean, that's what
Yeah,
I'm not a property lawyer, but I remember from law school, I think a quitclaim deed transferred that to BISD just as you had asked for, Judge.
Okay. Well, he will obviously be given whatever credit if there's tax indebtedness. I've never figured a way to prioritize over the tax man. I don't know how that is supposed to work, if it's possible, but taxes are going to have to be excised out of that value. And then whatever the remaining value is, the court will intend to give fair credit toward Mr. Walker's obligation. And if there's an issue on that, we'll resolve it.
Okay.
Y'all about it. But I haven't heard anything yet myself about what has been done in taking the tax obligations, if they exist, out of that. But I understand there is. I haven't looked in.
That was our information, was there was a substantial tax.
What we'll do is somebody I'm going to ask if the state would call BISD and see where they are in the recoupment of those the value on those properties and what net has been determined based upon tax obligations, which are already always prioritized. But whatever is not taxed is going to get credited toward Mr. Walker's obligation under the court order in this case. So,
Judge, could I just mention one thing? I know we always have a record with your wonderful court reporters there. I'm going back off memory right now, but I thought what we had done for the purposes of restitution and being paid is we agreed on a much lower number, we being Mr. Walker and I, than he thought it could be sold for. I know it wasn't selling for what he had it listed. And we were hoping, it was our understanding that that number that we had on the record last time was what we were going to apply to his credit towards his restitution. And I don't have the number in front of me. I think it was 280,000, something along those lines. I just wanted to mention that was our understanding of what had happened at our last setting, and I am going off my memory.
well, whatever the credit's going to be, it's going to be a new arithmetical determination.
Okay.
Not, it's going to be what it actually becomes when the numbers are put together and the taxes are taken out. And then if there is another issue, then I'll resolve it if it has to get resolved. But until, fair market value is, I think that's back in law school. One of the first things we learned in property, right? What a willing buyer is willing to pay and a willing seller is willing to sell it for. And whatever that meets, that's fair market value. And if that can't be determined, it just can't stay in twilight zone. The court will make a determination in abundant fairness and based upon input of all the parties. And if I have to resolve it, then I'll make a resolvement, and that can be an issue that can be taken up later. But it's going to get resolved one way or the other, as expedient as this court can do it, and in all fairness possible to all parties, the obligor and the obligees. So, yeah, but I just, I don't believe it's been. Of course, what would answer it is the properties. Somebody comes up and says, "We want to buy those properties," and then that becomes a fair market value determination if that can be if an agreement can be reached. So that's what he would be given credit for there. That's an easy one. The question then becomes, if they're just sitting there and they're not transferred but to a willing buyer, then obviously it just doesn't sit there in twilight zone. It has to get resolved in all fairness, to a defendant and to the people. And we take that up if and when that happens. But there are answers to it. It's going to be done one way or the other. And everybody knows when we're dealing with these can be excruciatingly time continuing, where we can't get things done immediately or quickly as we would want. But the importance is the assets that the defendant did have been, that can be transferred, have been moved over to the taxpayers.
That's right, Judge. I think we did
Beneficiary.
that yesterday, or I'm sorry, last setting.
Yes, sir. And that was what was most important for this court.
Okay.
And again, that is those values which this court understands are significant amounts. We expect ultimately to be liquidated or given credit to the defendant for. The other is what he has been doing as he promised, and that was pay monies while this, pay as much as he could toward the balance on restitution, which is a lot of money. 600, 6 figures plus. And we have over $12,000 applied toward restitution, not counting those properties which were on the tax appraised of over a couple $100,000, I believe. But the defendant made promises. Mr. Walker has promised from the outset of this that he is willing, ready, and able to work, and had had opportunities from friends or others, acquaintances, to help him make income to pay the minimum of $1,000 per month that he has ordered. That's not being done.
Oh, I thought he was paying that.
Well, as of today, $12,194 has been paid, and over the time that we have, from the time that we have ordered this, that doesn't factor out to $1,000 a month. But let me finish. What I want to know is, are you meeting that obligation of $1,000 per month?
Yes, I have.
Yes, sir, at least. If you can pay more, you can pay more. All right. So that's what I'm concerned about. That's good. That's okay.
Okay.
Because that has been since that order.
Yes.
That's important. The next thing is, are you able to pay more than that?
Not at this time.
What is being done? Because you represented, the opportunities were there to make an income that was more than just $1,000 a month if he paid for restitution, because this court has ordered a minimum of 1,000, but I want as much as you're able to pay to the taxpayers.
That's what I've been doing.
So what are you doing to be able to pay more than $1,000 a month? And are there any, is there any hope of anything soon being accomplished in that regard to increase this?
Let him know about the two home warranty companies, Calvin.
Yeah. I've applied for several jobs, and I got a couple of contract offers with Choice Home Warranty and American Home Shield. But I only get the jobs if they call, they have to need my assistance at the time.
Since when has that been an opportunity for you? Since when? How long have you been waiting?
About a week ago. I applied for
Okay.
several jobs.
Okay. Well, so what are y'all thinking about? Where does it look on that? What's realistically hopeful?
I think that my understanding is currently with his limited income he's getting from his son's company, and I think this has all been reported to Miss Hunter, I believe, and his Social Security payment that he receives monthly. I think he's still the last month or two when he's paying the increased amount of 1,000. I believe he's been borrowing a certain amount to get to the 1,000, to be upfront with you, Judge. And I believe that has been reported to Miss Hunter. And if he can get more money and so he doesn't have to borrow from friends, I think that he could then pay. I used to have American Home Shield insurance. I thought it was a waste of money on my side, but hopefully they'll get him some work to come out there. I could never get anyone to come out to my house, but that's not his fault. That was American Home Shield's fault, quite frankly. But I think that Mr. Walker's doing what he can. I know he'd also sold those trucks before the last setting and paid that money to the county for BISD as well. So, Judge, I don't think I have a definite answer other than right now he's still borrowing some amount of money to make that 1,000 each month. And if he can make more than $400 or $500 additional money, he could probably start throwing a little extra on top of the newly ordered 1,000.
Okay, well, your less than hopeful review of your past
Right.
experience with that organization doesn't give me a lot of hope.
Well, that was on the insured side, Judge. So,
What state say? Anything you'd like to add?
No, sir.
All right, and all the appeals briefs have been filed?
They will be at the beginning of next week, and then it's
That's up to
entirely in
the-
the hands of
Okay,
a different set of judges to decide what to do.
all right. The appeals brief from the state's going to be filed here shortly.
yes, sir.
So it'll be in the hands of the Court of Appeals and hopefully an opinion will be determined, a resolvement will be determined expediently.
Yes, sir.
Until then, the defendant continues to be ordered to pay at least $1,000 per month toward restitution payable to the Beaumont Independent School District. And I am not aware of any other assets he personally owns that can be acquired and ordered by the court to pay. Is that what everybody believes? That with the properties from Pleasure Island that have been ordered, turned over, then it's his homestead period that he's left with. Is that what everybody states? Mr. Walker, right?
That's correct.
So it's an income issue now in employment and what I will do is review this in 60 days on a status and of where the appeal is and what other income opportunities Mr. Walker was able to acquire. But at the beginning of this, Mr. Walker, I'm going to remind you, you were very optimistic about being able to get employment and work for folks. And that's just not paying off. That optimism is not resulting in an income that you had proposed or expected. And I expect you to vigorously attempt to seek all opportunities for additional income so as to repay the victim in this case as much as possible. Are you doing that?
I am.
Okay. I want you to pass on to the probation office every week an update on what efforts you were making so I can be confident and satisfied that you are making all vigorous attempts as possible. Who you've talked to, what applications you've made, copies of applications that you make. And I want that weekly. Do you understand, sir? That will be a condition of this bond. And how often do you meet with Mr. Walker himself?
Every 2 weeks.
Every 2 weeks. Okay.
The most recent job search.
Man,
Mhm.
yeah, I'm looking at something since December, which shows a job search worksheet that does the defendant fill this out or is he telling you this and you're filling it out?
He fills it out.
Okay, but this is your handwriting.
That's correct.
Okay. And how often are you getting this?
Every 2 weeks.
Every 2 weeks. Okay. And this is a product of 2 weeks right here
Since December.
since December.
Yes.
It's about a month. It's about a month, Judge.
Does he fill out a new sheet each time or just add to this single sheet?
He adds to that sheet and I initial and put the date that I observed.
Okay, all right. So since December, we're looking at eight independent entities that the defendant has contacted for job opportunities.
Yes.
Okay. And that's since December. Okay, that's good.
There was another sheet there.
Okay, because this is since December 15th. And so that's that's 5 weeks, and that's less than 2 a week, you know. But you said there's more. Here. Thank you. No. Well, Miss Hunter is pretty good at keeping bookkeeping accurate, so we got to ramp up the quantity of attempts, don't you think?
Judge, I'm seeing 2 a week since up until last week,
Yeah, it was
if I'm reading it right.
5
15,
weeks.
17.
It was 5 weeks, 8 in 5 weeks, so it's less than 2. Mm.
Right. I'm just looking at the dates. I'm just seeing the 2 a week up through the last week.
What do y'all think about that? I mean, is that enough? Is that satisfactory? Because number one, this is nothing's being accomplished except we're making attempts, but we've got these online applications have been filed. That you file that, and that I know, I understand. And how long does that take? I know what an application doesn't take a week to do, but I can understand meeting with people might take longer after these applications, but most of this are just online applications being filed. Only 4 meetings with particular representatives of potential employers are here. I mean, there needs to be more vigor, is what I'm saying, sir.
Do those online.
I know, but I know how long it would take to do an application. It doesn't take that long. Every day, your obligation on your bond is to be striving for income every day.
Then that's
Well, it's arguably, it may not be vigorous enough.
Yes, sir.
What do you think, Mrs. Munn?
As noted on some of these job searches, some places are not hiring. So Mr. Walker has been directed to apply to places that are actively hiring.
Well, he won't know until if they say we're not hiring, then he needs to move on with that. But he's picking up the phone, and if it's a dead end, you just don't drive into the dead end. You turn around and try another, and that's what I want is to be vigorous in attempting to get more income to pay the taxpayers. And I'm not sure that I'm satisfied yet on this. There needs to be more vigor. Anything else? Okay, when did we set a review?
3/27. It will be about 60 days, so hopefully we'll have 3 of them.
Yeah.
Yes.
What was the date, Judge? I'm sorry, I didn't hear that.
Middle of March.
3/27.
3/27.
Can I just,
3/27.
do you mind if I check and see if that's spring break, Judge? I'm sorry.
Okay. Yeah, let us know.
Okay, I'll let you know. Your staff's been great working with me, so I think I'm good though. Thank you.
All right. Okay. you know, in that period of time, in 2 months, there needs to be more than just that amount of online applications, which are just 8 attempts. There, or this court's going to act.
Okay.
Okay.
Thank you, Judge.
You think it's a mistake?
No, sir.
Thank you. We are in recess on this. Get a resetting, please, Mr. Walker. Okay, I have this man.